Hey everybody, I'm Paul Rabalais. I'm an estate planning attorney in Louisiana, and I make these videos to help Louisiana people and people around the country really understand some of the issues involved in setting up and maintaining an estate plan and making sure that what you have goes how you want, where you want, minimal or no government interference, keeping it all in the family the right way. So one of the issues that comes up in almost every conversation I have is somebody will ask me, Paul, should I have one executor or should I have more than one? So maybe the background is married couple comes in, they've got kids, let's say they have 3 kids, and they'll name their spouse as their first executor, but then it's always suggested that they name backups, and that's where they ask, what's better, one or more than one? And it's usually one or more of the adult kids. I'll preface this by saying that the same conversation takes place when someone uses a revocable living trust in an attempt to avoid all of the probate difficulty when they die. Just the language is different. It's, Paul, who should our successor trustee be? Should we name one or should we name more than one? So I'm just going to use the word executor. I'll probably throw in trustee throughout the video. Okay, so some of the issues involved there is when they ask me what's better, should it be one or more than one, I got no idea because every family circumstance is different. It depends on a lot of things, family dynamics, what do you expect the children's roles to be, who's responsible and who's not responsible. There's probably a better way to ask that question. And quite frankly, what situation do you think would be best for your family? So, some of the people who say, well, couples say, well, let's appoint, this one child as our executor or trustee. They're probably saying to themselves, that child is the child that's most responsible. They get things done. They have good relationships with our other children. If our house needs to be sold, it's going to be easier if that child can do it by themselves and then divide up the proceeds among the heirs or legatees or beneficiaries, whatever you want to call it. So the people who are thinking, one is probably appropriate, probably are thinking that. The people who are thinking, well, let's name all 3 of our children as the co-executors. What's going through their mind is, we don't want to offend anybody. We want to treat all of our children the same. And there's not anything wrong with that. But the fear of offending one or more children really trumps it will likely get done quicker and with more organization if we name one. So, those are things that go through people's mind. What's the executor, whether it's one or more, what is their role? Well, it's after both spouses die. Executors got to typically work with an attorney, not so much so perhaps when they have a trust and there's a successor trustee, but an executor is going to have to hire a lawyer on behalf of the estate, going to have to collect all of the asset information, going to have to make decisions on whether things should be sold or not sold and dispersed to the family, going to have to sign lots of court pleadings and maintain good relationships with all of the parties that are involved and just kind of see this whole thing through. So a couple of unique aspects in our Louisiana law is that when you name co-executors, and everybody assumes incorrectly here, when you name co-executors, for example, the couple has 3 children. Well, let's name all 3, and if 2 of them feel like the house should be sold, the 2 of them can outvote the other one. Or the other one sometimes is not real cooperative, but we got 2 who will be cooperative, so naming all 3 is okay. The 2 can get things done because they're a majority. Well, our Louisiana co-executor rule says that unless you provide something different in your will, the co-executors must act jointly, so 2 can't outvote the other one. If something has to happen, an estate bill needs to be paid, an investment needs to be sold, a house or piece of property needs to be sold from the estate, it's going to take all co-executors acting together, not just 2 of the 3, but 3 of the 3. Nobody really understands or assumes that that's the case, but it's the case. Now, if you have a revocable living trust and using that as the way to kind of replace the will and provide for who's going to handle things when you die and where it goes outside of all the kind of government interference and all the probate stuff. Then when you have a trust and appoint successor trustees, unless you provide differently, a majority of the co-trustees can act to get things done. So if you have 3 successor co-trustees, 2 can take action and can, kind of outvote that third one who maybe doesn't agree with the decisions of the other 2. So differences there, you need to be aware of that. So bottom line there's no one way that's just the correct way. It's based on what you're trying to accomplish, the family dynamics, who are your children, where are your children, what are their organization skills, what are their relationships with each other like. All of that typically goes into that decision of who's going to handle all the stuff that needs to be handled when you or you and your spouse pass away. So hope that gives you some guidance. Really a decision that you need to make. There is no kind of one best way. The idea here is get informed and make a fully informed decision, and then get things done and in place, so that you can move on and you can have assurance that you've set things up in a manner that's best for yourself and your family, avoiding lots of the problems that other families who don't do this face. Okay, so I'm Paul Rabalais. Hope that helps. Go ahead and have a great day.